Altfield. It is my honor to be serving you as your county court judge. We have before us State versus Justin Bieber. If I could have counsel for the parties, please announce yourselves for the record.
Juan Perez for the State.
Thank you.
Good morning, Your Honor. Roy Black, Mark Shapiro, and Howard Shremnick on behalf of Mr. Bieber.
Good morning. Good morning.
Good morning, Your Honor. Scott Ponce on behalf of the Miami Herald Media Company and CBS television stations.
Okay, thank you.
Good morning, Your Honor. Deanna Shulman on behalf of the Associated Press, CNN, Brooks Media, Inc., the Orlando Sentinel, and the Sun Sentinel.
Okay, thank you. Okay, we have the defendant's motion to prohibit public disclosure of videotapes. Quite frankly, I had the opportunity to review the pleadings filed on behalf of the defendant, the state, and the media. However, about 20 minutes ago, I just received this, a 2-pound packet of documents. I'm not an Evelyn Wood graduate. I did not have the opportunity to read this. Have the parties received copies of this response?
Yes, sir. That's the defendant's reply.
This is the defendant's reply, correct. State, have you received that as well?
Yes, Your Honor.
Okay. I, quite frankly, would like to read what you've filed. Certainly, I think that the court needs to consider everything before it makes its ruling. But what we can do at this juncture, there are a few questions that I have. I will allow some argument, but quite frankly, we may have to continue this matter so that I'm at least apprised of all of the appropriate authority that has been cited by the defendant. Quite a lot of case law. I haven't read the response itself, so I really don't know if in fact there are some new things that I need to consider. But with that said, there are a couple of things that I had some questions about. Give me 1 second. Where was it? The issue is whether or not these surveillance videos are public records, and I need to find out if are all parties agreeing that these are public records. I'll just hear from the defendant first.
Your Honor, Mr. Shremnick is going to handle the legal part of this. When Your Honor said that you were going to look at these materials, might I also suggest that you have an in-camera proceeding, or perhaps the state and us present, to direct you to where on the videotapes are the short, I think there are 4 sections that are at issue here. All the rest of it we agree can be released, but they're just 4 short sections. So when you're thinking about that, you may want to order a hearing, an in-chambers hearing, so otherwise it's 10 hours of tape. So we can show it to you in a couple of minutes.
I'm glad you brought that up because it was, and I was presented with some discs by the state and made sure that all parties were aware that I had received those copies, and we learned that it was just hours and hours, and I was not going to be spending my time trying to figure out what was relevant to the proceedings. So that's a good suggestion. However, now that I know that you are not seeking the prohibition of the disclosure of all of the video, it's just a certain portion of the video, I guess kind of puts this into perspective. Now, with respect to being a public record, are we all in agreement that this is a public record?
Not necessarily, Your Honor.
The public records exception is triggered only by virtue of the states producing those items as part of the discovery in the criminal case. Of course, discovery in a criminal case is governed by Rule 3.220, and that rule does provide the court with the authority to restrict and regulate the dissemination of such discovery. And so until such time as Your Honor rules, based on our motion, that these materials would not qualify for some restriction or some regulation under the discovery rules, we believe then they would not qualify for dissemination under the public records law, the Sunshine Law here in Florida. And I would direct the court's attention to a case that was cited in the pleadings that I think pretty much sums it up for all the parties. It's the case of Post-Newsweek Stations versus Doe. It's a Florida Supreme Court case, November 1992. It's cited at 612 Southern 2nd, 549. In that case, emphasizes that, quote, "The public does not have a universal right to all discovery materials. The purpose of criminal discovery are to narrow the issues of the case, to ascertain facts that will be relevant at trial, and to avail the parties of information that will avoid surprise tactics in the courtroom." I continue quoting, "Discovery is not intended to be a vehicle for the media to use in its search for newsworthy information." So the first step in the analysis, Your Honor, is to determine whether these materials, which are being produced as part of discovery, should be restricted and regulated under Rules 3.220. If you could pass me my iPad. Thank you. I've got the benefit of technology. 3.220E, restricting disclosure. 3.220L1, motion to restrict disclosure of matters. And 3.220M, in-camera and ex parte proceedings. What Mr. Black has proposed is the first step in the proceeding, asking the court in camera to review the limited portions of this discovery material so that Your Honor can make an independent assessment of whether the court should restrict public dissemination of the materials that are being turned over to us in discovery. Now, we concede that the Florida Supreme Court has ruled that matters that are turned over as part of discovery do become public records. There's no doubt the Florida Supreme Court has so ruled. But given the rules of criminal procedure and your discretion to restrict and regulate the dissemination of that discovery, we submit that the court should exercise that discretion after in-camera review.
What you just said begs the question. You just said that these documents, once discovery has been invoked and is now a part of discovery, is public record. So are you conceding that these surveillance tapes are now public record?
Once they become part of the discovery and they are appropriately disclosed as discovery, we concede that the Florida Supreme Court has ruled that they would otherwise be subject to public records disclosure.
So, again, I have on my timeline that the state had listed the 9 videotapes on discovery on February 6, 2014. You're conceding that at that time that they became public record?
We'll certainly concede when we took possession of them, which was, I believe, yesterday, certainly no later than yesterday, they would otherwise become public records, subject to the regulations that I've suggested, Rule 3.220.
All right, go ahead. I'm sorry.
And so in exercising your discretion after what we submit the procedure being an in-camera review, and I don't know if the other parties object, that was the proposal we've made in our pleading, is simply to stay any public dissemination until you, Your Honor, have had an opportunity to review the materials. We believe, based on our limited review of the materials so far, you would conclude it would be demeaning of the court to authorize the public dissemination of a arrestee, a person in custody at the Miami Beach Police Station, being asked to urinate in public view, subject to videotaping, albeit behind a low wall, something along these lines here at the bar. No different than it would be offensive, demeaning, and certainly offend the dignity of the court for someone to do that act behind a low wall in the courtroom. And that's exactly what we understand the videos, at least what we've seen so far, depict.
Is there audio in these videos?
Not that we know of.
No, Your Honor.
Okay, thank you.
And the cases that we've cited, and I understand the court only received the copies early today, we've highlighted the number of judges who have come to the same conclusion about the rights of privacy, which no doubt include the act that's depicted in the image. Even without total nudity, the act that's depicted, the act of urinating, is an act that I shouldn't even have to argue is an act that should be conducted with some semblance of privacy. And to the extent that the Miami Beach Police Department filmed that act, it's simply not something that the public has any right to view. I would direct the court's attention again to the same case from the Florida Supreme Court, Post-Newsweek versus Doe. Citing the Barron case from the Florida Supreme Court, quote, "It is generally the content of the subject matter that determines whether a privacy interest exists that might override the public's right to inspect the records." You might recall, Judge, I think both of us are old enough to remember the case, it was called the Willits case back then. I see the court is smiling, and it's because you and I are old enough to remember that. That was the case, and it's the one that went to the Supreme Court where the defendant was charged with a prostitution ring. Search of records discovered by the police included names and addresses of potential Johns, none of whom were charged. And those Johns had filed a motion to intervene to restrict the dissemination of their names and addresses. But in addition, the Johns had requested that other information, and I hate to have to say it, but it's directly from the Supreme Court, quote, information relating to genital size and sexual performance was included within those materials. And the judge in that case ruled that an ex parte in-camera hearing would occur without view of the public so that the judge could decide for him or herself whether such material should be publicly disseminated. It's exactly what we're asking for here.
Did they categorize those records as public records?
Yeah, there was no doubt that, as we indicated earlier, once they became part of discovery, they could very well be public records subject to the limitations. The Florida Supreme Court never ruled on whether the more explicit information that I just described, whether those indeed would be restricted from publication. It never became an issue.
So the operative act that you're relying upon is the invocation and receipt of discovery, making these surveillance videos public record. So are you saying that until that time, it is your position that they were not public record?
That is correct. They were law enforcement materials that would not otherwise be subject to disclosure, and indeed the media has relied exclusively on the invocation of discovery in seeking the public dissemination of these materials. And in footnote 3 of the Supreme Court's decision in Post-Newsweek, the court wrote, because the trial court has not conducted an in-camera review of any information other than the names and addresses, and because the trial court has not ruled on the disclosure of any other information, we do not address whether information should be released. However, we note that the details of an individual's life dealing with non-criminal intimate associations falls within a protected zone of privacy. Of course, in that case, it dealt with more explicit sexual activity. In this case, we're dealing with the act of urination. And we submit, given society's expectations, given the privacy interest that we all expect with those bodily acts, there should be no difference in terms of the rights of an individual who's arrested against his will, in custody against his will, detained against his will, and forced to urinate subject to the view of officers and now we know cameras against his will. There are public policy reasons which the court should consider. First, as part of our motor vehicle laws, the legislature itself has indicated that when a urine test is being administered, and I cite now from Chapter 316.1932, quote, maintain the privacy of the individual involved, comes right from the statute. The urine test shall be administered at a detention facility or any other facility, mobile or otherwise, which is equipped to administer such test in a reasonable manner that will ensure the accuracy of the specimen and maintain the privacy of the individual involved. So the legislature has announced its intention to maintain privacy, and for public policy reasons, we can all understand why that would be important. For if motorists who are pulled over for a DUI and then asked to submit to a urine test were told that that act would be filmed and disseminated publicly, if I were to volunteer, even if I'm not intoxicated, to dispel any suspicion of my intoxication, I were asked to urinate in a cup, but I knew that that act would be disseminated publicly and in the media, it would certainly discourage me from doing so. And so there are strong public policy reasons for this court not to hold that as a matter of law, such videotaping can be disseminated to the public. Federal law also reflects a strong privacy interest. and the court will have the opportunity to review the cases. We cited many federal cases, many of them under the Freedom of Information Act. And we start the pleading with a Supreme Court of the United States quote, "Inmates in jails, prisons, or mental institutions retain certain fundamental rights of privacy. They are not like animals in a zoo to be filmed and photographed at will by the public or by media reporters. Just because someone is arrested, taken into custody, held at the police station, it doesn't mean that he or she has forfeited his rights of privacy, and certainly not in those bodily functions that are at issue in this case." The Sunshine Law is designed to promote the public's awareness of government functions. We understand the purpose. It's not designed to promote the public awareness of a human being's bodily functions. And that's where this motion by the interveners is headed. Sometimes it's hard to draw lines, Your Honor. This is not a hard line to draw. All we are asking, first, is that the court hold an in-camera review. And second, if what you see on that videotape is as what has been described in court, that the court hold as a matter of law that when a person arrested, a presumptively innocent person is in custody, if the police film him or her urinating, there's no reason why the media should make a spectacle of that event, even if it happens to be someone who is high profile. If I may have a moment to consult with my
Sure.
colleagues. Judge, that's all I have at this time.
Actually, I do have a question, though, because it is an issue that I was thinking about. Is the analysis any different when there is a public figure involved, as opposed to a regular private person who doesn't have access to the media, is not in the public eye on a daily basis?
I don't think so. I don't think public figures have any less privacy interest in urinating than a private figure.
Understood. As far as urinating, I understand. But in terms of just the analysis alone, as far as their ability to rebut any allegations that might have been made against them, they have the ability to get on, on the media, have interviews. They're well known. They put themselves out into the public. Do you not think that there's any difference in the analysis?
I have seen no case that would distinguish between public figures and others in this context.
Okay. Thank you.
Yeah, Mr. Black points out, and I assume that's where the court was finding its source of the question, which is in libel law. I think it's New York Times against Sullivan is the
yes.
case, U.S. Supreme Court case. And so in the libel case, we'd be in a different area of the law, but in the case of privacy rights,
But
I
it's
don't
still
see
an
a
injury,
distinction.
whether it's an injury. And how you categorize the injury, certainly I think it's still an injury. So that's why I was thinking about that analysis. But okay, thank you.
Very well.
Okay, I'll hear from the state. Thank you, ma'am.
Good morning, Your Honor. Penny Brill, Assistant State Attorney on behalf of the state. Just very quickly, I just want to make sure you understand the state's position, which is that we believe that technically this became a public record at the time of the filing of the pleading, not necessarily the time defense counsel received it, because the pleading says that this is now available for review and copying. So the fact that a defendant never picks it up doesn't make it any less a public record. Doesn't, anybody, they don't have to, it's available. But it doesn't matter because they have received it. I just want to put that point for our purposes. And the reason we did not provide this pursuant to public records request by the media is because we recognize the issue of the privacy rights. So we wanted to give the defense the opportunity to come to this court under Rule 3.220 and ask for a limitation if that's what they wanted to. So that's why, and the original motion said all tapes. It didn't just say this particular tape. So I wanted the court to understand what our position. We haven't been stonewalling the press. We were just basically doing what we had to do under the rules.
Okay. Forgive me for interrupting, because I have an issue. So are you telling me that you do not believe that these surveillance videotapes at the jail, or I don't, are these Miami Beach surveillance or
Miami Beach.
Dade County Jail surveillance?
Miami
Miami
Beach.
Beach surveillance, okay, are not public
No,
records?
no, we believe they are. No.
Okay, so
No,
they are
no.
public records.
Oh, yeah,
That's-
no, we're not arguing, I'm just saying that they became public record sooner than when defense has argued that they became. That's our just,
Okay,
it's a little different, but right now,
in
they are
other words,
definitely public record.
had discovery not even been invoked, these would have still been public
No,
record within
no.
the custody?
No, under the case law, until discovery is invoked, and I cited the case in my response, the City of Miami versus Post Week Stations, Florida, Inc. That's the Joe Corolla
Yes,
case.
okay.
Where they initially invoked discovery, then they uninvoked
But
discovery,
remember, there was
and
a
before we
specific
did anything.
exemption because it was part of a criminal investigation. That was the issue. So that's where that case is distinguished. It was an exemption to the disclosure. And once they pulled it away, that exemption now applies.
Well, all of this is technically ongoing criminal investigation. And it would normally be exempt from the public view, except for under the case law, once we give it to defense counsel or make it available to defense counsel under discovery, it then becomes public record.
All right, this is
Okay,
this
so
is the
that-
way
that-
the court, and correct me if I'm wrong, but this is the way the court sees it. Let me just see if I can find it. The definition of public records. Public records means all documents, papers, letters, maps, books, tapes, photographs, films, sound recordings, data processing software, or other material, regardless of the physical form, characteristics, or means of transmission, made or received pursuant to law or ordinance, or in connection with the transaction of official business by any agency. It sounds to me that it is part of the ongoing daily routine of the Miami Beach Police Department to monitor the activities of inmates, the processing, the integrity of the process. So it seems to me that it is a public record at that juncture. Now, if there is an ongoing criminal investigation, then it becomes exempt until such time as that investigation is completed.
Not exactly.
Okay, no, look,
Not
you know,
exactly.
that's,
I think you have to look at the Bent case basically says that just because it happens in a police station, that Bent is a situation where they, as a matter of course, the jail in Broward County was recording all the inmates'
Right.
phone calls. And that case, they said that did not make it public record just because the police did that. So just because somebody comes
but
into a
again,
police
they
station.
distinguished the contents of the conversation versus the logs, the monitoring. What we're doing here is we're monitoring.
Well, yes, we're monitoring, but there's also what's captured in that monitoring. And the point of the matter is, in our situation, because we believe that those tapes are part of our criminal investigation, and then we turned it over to them, it became public record. But if we had never turned, if they had not invoked discovery, or if we, for whatever reason, did not turn it over to them, then it would not be public record.
And you're saying because you're saying, I don't want to argue semantics here, but are you saying that even though it's public record, it is exempt from disclosure, or are you telling me that it is not public record
No.
at all?
No, I am saying that because it is part of a criminal investigation, that is an exemption
An
to
exemption.
the public. It is technically, yes, it is, by definition, I think it is a public record, okay? But some of it, then you get into whether or not the privacy isn't, like, the content might be a little bit different.
That's a
It
separate
doesn't
issue.
become a Bent issue. That's a different issue. That's a little trickier. Because again, the content of that phone call in Bent was, the 4th District said, is not a public record. Even though it was taken in by the Broward County Jail pursuant to their normal thing, and it was kept in their custody the way they normally do, they found in Bent that that was not a public record because the actual content had nothing to do with what they were doing. Okay, but this is a little different, and there could be a distinction, which is why I sort of kind of leaving it up to the court to make that decision. But on the other hand, because we have taken possession of that, and we have given those tapes over to the defense, it is now our exemption, which we would have had for ongoing criminal activity, is no longer valid because we've given it to the defense. And we've made it available to the defense, and they have never withdrawn the request for discovery, so it doesn't fall under the Corolla case. So therefore, it became public record as soon as we made it available to them. The fact that they didn't come and pick it up or they didn't get it right away doesn't change the fact that we had made it available to them.
So we're
that's what I
clear.
wanted to make clear on.
So the state's position, because quite frankly, I was unsure as to what the state's position
Our
was.
position is whatever you want to do, Judge.
Well, yeah, I understand that, but I just want to make sure, though, that the state, because the state is now the custodian of record, okay?
Yes.
So as the custodian.
Well, actually, the city of Miami Beach and we have.
Well, once you took possession of it, though, once you took possession of it, you are now a custodian of records under the statute.
We are, yes, as
Okay.
well as, I'm just saying, public records demands have also been made to the city of Miami Beach Police Department
Okay.
as well.
Okay,
So-
but my question is, again, as the state in your pleadings, I just want to make sure we're all on the same page here. You are not claiming any exemption whatsoever?
No, we are not.
Okay, I just want to make sure, because you are required under the statute that if in fact there is an exemption, you have to file
No,
in
we're-
writing the specifics of that
No,
exemption.
we are not
Okay.
claiming an exemption, I just wanted, but we agree with the defense that Your Honor should look at this in camera. We've had other cases, high publicity cases involving celebrity victims, actually, where we have gone in camera under 3.220 and had certain things limited to the press for discovery purposes under the same argument defense counsel has made and has, so we've done this before, it's nothing new, so we
So-
join with that you need to have it in camera review to determine.
I have not seen the videos. I presume you guys have seen the videos. Are you, okay, you have seen the video. Is it the state's position that you are in agreement with the defense to have an in-camera hearing to determine if in fact there are images that are portrayed in these recordings that invade the privacy of their client?
Yes, Your Honor, the state does agree with the defense that there should be an in-camera review. I can tell you that, based on my viewing of the videos, I will agree with the defense that there is something blocking the defendant, probably about as high as that right there. So I do believe that you should review the videos in camera and make a determination.
Okay.
That's our position.
Okay, thank you. Okay, who do we have next? Good morning.
Good morning, Your Honor. Scott Ponce on behalf of Miami Herald Media Company and CBS television stations.
Okay, thank you.
Do you want to talk about whether it's a public record?
Sure.
Okay. In the circumstances here, there's two ways it could become a public record. And the second way kind of moots the first way. But the first way was, and Your Honor was talking about it, if the video, when it was taken at Miami Beach Police, was found to, the cases talk about formalize, perpetuate official agency business in the hands of Miami Beach Police, theoretically, it could become a public record. That's one way this videotape could become a public record. We're not going to have that conversation because what happened here is whether it was a public record in the hands of City of Miami Beach or not, once it was turned over to the defendant as discovery or made available, the cases say, as discovery, it became a public record. So whether in the hands of the city it was a public record, whether the video perpetuates, formalizes official agency business, whether it monitors, whether that, all of that is irrelevant once it got handed over as discovery.
Okay.
And so that's where we are. So the question is, before you, Your Honor, is, yes, it's a public record. That's number one on the decision tree. What the defendant's motion then asks is, do you have the ability to restrict public access to this public record? And that's where the rub is, as they say. A couple of things about that. There are ground rules dealing with the public records laws and exemptions, and we've cited these in our papers, which Your Honor said you had a chance to read. One is, we hear a lot about legislating from the bench and whether you can do that or not. In this context, in public records, the Supreme Court has made clear in the Waite decision that the only way a public record can be held back from disclosure is if there is a legislatively created exemption. So when Mr. Srebnick talks about there's all these public policy reasons why maybe something should be private, that doesn't matter. What matters is, has the legislature created an express exemption? And it's not up to us to divine whether there should be public policy reasons that maybe it should be exempt. If there's not a legislatively created exemption, you can't hold it back. Second rule that comes up a lot, and this is cited in our papers too, and frankly it sounds pretty relevant based on what I've heard counsel say, is that if part of a public record is exempt, if there's an exemption, and part of it is exempt, you redact what's exempt, and you produce everything else. So when we have appear to have an agreement here that there's only four vignettes, I don't know what the proper word is, 4 shots that are an issue, everything else should be released now. So then we talk about those 4 vignettes, and I've not seen the tapes, but listening to counsel, it sounds like the defendant's urinating in them. And I'll cut to the chase, and I'll use semi-blunt language, I think the issue is, do we see his penis or do we not see his penis? If his penis is somehow visible, under the public records rule, we redact what's visible, and the rest goes out. So if it's him from the waist up, there's nothing exempt about that. If it shows something in his private parts that should be redacted, we put a black bar over it and the rest goes out. Those are the rules of public records law. I want to talk about post-Newsweek, the decision that Mr. Shrednick talked a lot
The
about.
Doe case, you mean?
The Willis case.
Oh, Willits. Okay.
The Willis case, the Does. There's a couple reasons why Doe is not particularly helpful to the defendants here. The first is, and the court took pains to point out, and this is an important point, that the people in post-Newsweek who were moving to have access to the discovery restricted were third-party defendants. I'm sorry, third parties. They were not defendants. And the court took pains to point out that we're talking about someone who's a third party who has not been charged with any crime. So we have a difference right off the bat in post-Newsweek and how applicable it really is here. And the court goes on to note, and the reason why that's important is in the same decision post-Newsweek.
So are you challenging standing? Are you saying that the defendant does not have standing?
No, I believe he has standing.
Okay.
I'm just saying when we're talking about privacy and we're balancing privacy rights, what's private? Does a person have a privacy right in how it depicts him at a police station after he's been arrested? What's relevant is this person been charged with a crime, or is this person just a third party out in the public? And the reason that's important, for example, is that in the post-Newsweek decision, at page 552 of the decision, the court says, any right of privacy that the Does might have is limited by the circumstances under which they assert that right. The circumstances here do not afford them such a right. Because the Does' privacy rights are not implicated when they participate in a crime, we find that closure is not justified. And so what the distinction here, Your Honor, is to what extent does a criminal defendant who's in a police station because he's been arrested and videotaped, what privacy interest does that person have in holding back and saying you should not release public records because I have a privacy? What privacy interest in it? Mr. Shrednick's not cited a case from a Florida court where a criminal defendant has said, I don't want videotape of me being released because it's private. I have a privacy interest when I'm in jail that videotape of me not come out. And there's Ms. Shulman is going to talk a little bit, and she's got a picture that she's going to show you of Mr. Bieber, a photograph that he himself posted on his website showing his bare bottom while he's urinating. So when you weigh that against, he comes to court saying, there's a video that shows me urinating. It's going to violate my right to privacy, and at the same time, he's posting photographs of his bare bottom. There's a disconnect there. There's also video footage of Mr. Bieber that's been publicly aired that shows him urinating in a mop bucket at a restaurant in New York City. So when we go back to Doe decision, and it talks about any right of privacy that the Does might have is limited by the circumstances under which they assert that right, these things come into play.
Do you believe that the public has the right to know or to see Justin Bieber urinating?
I'm going to make a distinction. I don't think the public has a right to see his penis. I believe the public has a right to see him standing behind a wall, doing what we know is urinating. And the public's right to know actually is not something that's balanced in here. Because it's a public record, the legislature's already made the determination that the public has a right to see it. The question is whether the defendant can bear his burden to show that there is a recognizable, legislatively created basis for you to say the public can't access that. I don't know how, Your Honor, far you want to go. You talked about wanting to see what defendant has filed. I'm happy to answer any questions
Yeah,
that you have.
have you had the opportunity? You had mentioned that the defendant did not cite any Florida case law, and I don't know if it is there additional case law that may contradict what counsel has represented? Because I have not looked at this yet. I haven't even opened it up.
I don't know that ever in the history of Florida this issue has been pressed by the media to see a man urinating. So no, I don't have a case where the media has taken the time and effort to
Forget about
argue this.
urinating. What about just the simple assertion that a defendant has never, at any time, wanted to prevent the disclosure of, you know, him being processed or in custody, or I mean, tell me if that's a fair representation of what you would say.
There is not a Florida decision that I'm aware of, and they've certainly cited, and I'm going to read their papers, where a court in Florida has held, we are going to find the privacy right in video of him at a jail, such that we're going to withhold that video from public view.
And Mr. Potts is correct, no Florida cases, but a legion of federal cases. Judge Oberdorfer's decision out of the D.C. District Court, in the best case, we cited it, we've provided the court with a copy, where the court held that it would violate the right of privacy of an inmate to be videotaped while they are in jail. There are several other cases. There's a case where there was a, you can just pass me my pad of cases. A case where there was a, one's behind there. A case where there was an altercation in a jail that was videotaped, and the court, federal court there likewise held that there was also a privacy right in not being videotaped. Mingo versus United States Department of Justice, United States District Court, that would have been Judge Howell for the District Court. So we have cited several cases, a Texas case, videotaping someone in jail. Just happens to be in Florida. We could not find any case litigated where the issue came up, but certainly in other jurisdictions it has.
But what I would say about that, Your Honor, is that the distinguishing factor we have here, and it's a point we made in our papers when we talked about Bess, and we talked about it before, is that I'm not saying the media has a right to go in to the police station and be there present filming Justin Bieber when he's giving a urine test. That's not what we're saying. The distinguishing factor of the cases that Mr. Shredman just cited with what we have here is that it's become a public record already. So whether the media has the right to go in and videotape someone in a jail, someone in their cell, that's not what we're talking about here. We're talking about documents that have already, the legislature has already determined are public records. So the case, for instance, when you get to the papers, the line that they start off with in their paper, which is a great line, I don't have it in front of me, that talks about that people in prison don't give up their rights, and that's right. But when you read that decision talked about, do I as the media have a right to go in and just film people in jail? And that's not what we're talking about here. We're not saying the media has a right to go in and film Justin Bieber at the police station. We're saying that a public record, a document that the legislature has determined must be given to the public, is there a basis to withhold it? So decisions talking about whether I can go in and film someone in jail are an opposite. That's not the issue we're talking about. And I would also caution you, Your Honor, when you go back and if you look at any of the FOIA decisions, the federal, we call FOIA the Federal Freedom of Information Act, those standards are different than the Florida standards. We're not dealing with the federal act here. We're dealing with the Florida Act, which frankly, is good for the media, it's bad for other people, is remarkably broad in what it sweeps in.
And Mr. Ponce would have the better day if it wasn't for the Supreme Court's decision in Post-Newsweek, which specifically says that the right of privacy can trump the media's right of access. And so the Wake case cited
When you
by...
say Post-Newsweek, we're talking about the Doe case?
We're talking about the Willits case.
The
It's the
Willits
easiest
case,
way to
Doe case,
remember.
okay,
Yeah,
all right.
because there's another Doe case, so we don't get confused.
Because I think there were a couple of other
So-
Post-Newsweeks.
John, those are everywhere.
Yeah. So if it wasn't for the Post-Newsweek case, Mr. Ponce would be on stronger footing. But subsequent to that case where the Supreme Court has said privacy trumps public access, that the media's rights have to yield to the right of the citizen who's been accused and arrested but not convicted, certainly. No different than anybody who's arrested would feel invaded if they learn that as a result of an arrest, which may not result in a conviction, they forfeit their right to urinate privately. And the idea that we'll just black out the private parts I say is insulting. To suggest, for example, that a movie depicting sexual acts should have a G rating if we just block out the private parts, or perhaps a PG rating. I mean, we're talking about the distinction here between NC-17 and X-rated. I find the argument to be insulting and demeaning of the court, that what he's asking you to do is to just fuzz out the private parts.
And this is where you write the legislature if you don't like what the exemptions are on. I would also say this, when Mr. Srebnick says the Doe case is good for him because it holds that a right of privacy can trump public access. It does say that. But, and this gets to the point I made that Mr. Srebnick didn't address, is that what case recognizes a criminal defendant's right of privacy in video of him at the police station? There isn't one. So yes, we can in a very nebulous, amorphous kind of way say the right of privacy can trump the ability to put public access to public records. But it's got to be nailed onto something. There's got to be some constitutional provision, which there's not, statute, which there's not, decision, which there's not, recognizing that a criminal defendant has a right of privacy in this. And Doe doesn't get him there. Doe expressly, and they take pains to point this out, involved a non-party, a non-criminal defendant, someone who was not charged with a crime.
Let me address that issue about the non-party. What Doe did was expand Rule 3.20 to allow non-parties to assert privacy rights. The right of the defendant, the litigant, existed before the rights of the third parties. So by no means does Doe restrict the rights of the arrestee. The rules were written for the arrestee's benefit, not for third parties. What Doe did was it allowed third parties, not litigants, to come in and assert their privacy rights. In no way does it diminish the rights of a person arrested and presumptively innocent. Also, the idea that as a result of someone being in custody, all of their bodily functions can be videotaped, subject to this smudging out on the videotape. This is, it doesn't surprise me there's no case in Florida having reached it, because no one would have the, to use a legal term, chutzpah, to record someone at a jail using the toilet. No different than if we put a camera in the courthouse toilet. Would we say then that the public should be on notice that they can't use the facility unless they want it subjected to the media's attention? Your Honor, I think it speaks for itself.
Just one more thing. The discussion in Doe about 3.220 and what it expands or what it limits, that was in the context of standing. The issue was whether these third parties had standing under the 3.220 to object. And the court said, yes, you do have standing. I'm not questioning Mr. Bieber's standing to make these arguments, but the 3.220 in Doe, post-Newsweek Willis, whatever we decided to call it, doesn't expand privacy rights at all. So, Your Honor, do you have any additional questions for me?
Not at this time, thank you.
Good morning, Your Honor.
Good morning, ma'am.
Deanna Schulman on behalf of the Associated Press, CNN, Orlando Sentinel, the South Florida Sun Sentinel, and the Scripps Media Inc., which owns two TV stations in Florida and several newspapers. On behalf of those clients, I would, of course, adopt and incorporate Mr. Ponce's arguments. We're on the same side of this debate. I just wanted to speak briefly to address a couple of points, one of which is it's my understanding from the discussions today that the vast majority of these materials are not in dispute. Those portions of the tape should be released now, today. If there is a dispute over, I think the state attorney's office indicated there were 4 clips among several that the defense would take issue with because those are the clips that depict Mr. Bieber submitting to the urine test, then that's an issue that we can save for another day, but everything else should be released today. Of course, as Your Honor is probably aware, under the Public Records Act, delay itself is unlawful, and while we certainly do not think that the state attorney's office has done anything to purposefully delay release, now that we know we're dealing with 4 clips, let's get everything else out to the public as the Public Records Act would require. So that would be the first thing I'd ask this court to do. I wanted to touch base just briefly on the Doe case or the Willits case that we've been talking a lot about.
Let me just ask you, how will you be harmed if there is a delay for the court to do an in-camera inspection?
I'm not disputing the idea of an in-camera inspection of those materials for which Mr. Bieber asserts a privacy interest. But he does not have a general private, having admitted that these are public records, whether by virtue of their maintenance by the PD or by disclosure and discovery, there is no applicable exemption or privacy interest asserted for the vast majority of these materials. The Tribune versus Cannella case, which was not cited in our papers, Your Honor, but it talks about the idea that
How do you spell that?
Cannella talks about the idea, Your Honor, that delay itself is unlawful. And what I'm hearing today is that for the vast majority of what we're dealing with, there is no exemption cited. There is no privacy interest asserted. So the public records law requires that they be released. In fact, the statute, I think, gives the agency just enough time to get the materials and get them and redact any information. It's my understanding these specific materials are kept in a large number of clips. Those clips that are not at issue here are each in and of themselves separate records. They should be released. Nobody's disputing them. They
Let me
were
just ask
released
the defense, have you had the opportunity to review the tapes? Do you know what is in them?
Your Honor, we have not watched all the hours. We have watched particular segments that we are aware of. The problem's going to be, I think, is a ministerial one, how to determine where these are on the tapes and what have you. I have no objection to everything else except for we believe there are 4 clips that we want to be kept private.
The operative word
rest
is
of it,
believe. You don't know. So if we don't
Right,
know, I'm not
we
going to
don't
go ahead
know.
and authorize the release of something that we're not sure about. So I would agree with the defense that I think it's prudent for us to make sure that we're on the same page, everybody, so that if in fact while we're in the process of having our in-camera hearing, if we're able to say, okay, all of this is not objectionable, we'll release it, it will be done at that time. But I can't go ahead and say, all right, let's just go release it with what they believe to be not objectionable, and then we find out later there happened to have been another clip that nobody saw or contemplated. So go ahead, I'm sorry to interrupt.
Yeah, well, Mr. Black just indicated with respect to what he has seen, if there's no objection, I would ask that the court have those materials turned over. You know, to the extent that they've seen them and they don't have an objection, let's get them out to the public. And I'm hearing murmuring over there that may indicate some agreement to that, but I'll let them speak.
we're remaining silent. We're not murmuring anymore.
Okay.
Gotcha. But Your Honor, I mean that's the whole point. If they're not disputing the release of certain clips, and I'm not suggesting we don't give them time to look at them, but they've already acknowledged that they've looked at some of them. Let's get them out on a rolling basis, because as the statute itself says, you get enough time to review it for redactions. Cannella says an automatic delay is itself unlawful under the Act. So if we can come to agreement quickly on some of these matters, you know, I would say that the Public Records Act requires that they be released. To address the issue of the Doe case, and to echo to some extent what Mr. Ponce has already said on behalf of the other media organizations, having come to the conclusion by admission or by analysis that these are public records, regardless of whether they were in the hands of the MPD, which the Miami Beach Police Department, which I would argue they are. As Mr. Ponce pointed out, that's a moot point because they've been turned over in discovery. What happens under the statute when they're turned over in discovery is they lose their public record status. And so the question becomes, is there a basis in Florida law to exempt them? That basis, and basically what the defendant is arguing for is the Bieber exception to the Public Records Act. He hasn't found a statutory or case law basis for that exception. The Doe case, as Mr. Ponce indicated, is an opposite because these are the rights of third parties not involved, not accused of crimes. In this case, Mr. Bieber is giving the very specimen that may be used to prove the crime with which he is charged. I mean, this is a man accused of driving under the influence. To some extent, if the tapes show a urine test being administered, that test may have relevance to the criminal prosecution. And there isn't a general, even the privacy interest recognized in Doe is overcome there because the court explicitly says, as Mr. Ponce pointed out, the circumstances of the right asserted control. The circumstances in that case were the same as here. When you are involved in a criminal activity, you lose your reasonable expectation of privacy with respect to those elements that relate to your involvement in that criminal activity. And that's exactly what has happened in this case. While I disagree that the court would apply the Barron standard in this case, I think it's totally an opposite. I just want to point out briefly, Your Honor, that even under that standard, Mr. Bieber's argument would fail because the privacy right recognized under Barron is limited to a right of privacy not inherent in the proceeding. Mr. Bieber submitting to a urine test in a DUI case is inherent in the proceeding. Now, Your Honor, I want to make very clear, I don't think I agree with Mr. Ponce. I don't think Barron has any application here. There is no Florida case in which the right of a criminal defendant to privacy in order to avoid the disclosure of discovery materials has been recognized. The FOIA cases cited by the defense are an opposite because FOIA itself has a privacy exemption. Florida does not have a general privacy right of privacy exemption to its Public Records Act. In fact, if you look at the right of privacy constitutionally recognized here in Florida, the right of access to public records is also a constitutional right guaranteed to citizens. And when this state passed the privacy constitutional amendment, it explicitly made clear that the right of privacy cannot trump the right of access to public records. It is explicit in the constitutional provision. That's Article 1, Section 23 of Florida's Constitution. So given that general principle that the right of privacy does not trump the right of access to public records, there has to be some other basis for which Mr. Bieber would claim an exemption. He has cited none. You will find none in the Florida court, in the Florida case law. You know, my clients don't have any interest as well. We haven't seen the videos, and we are always arguing blindly. My clients have no interest in seeing Mr. Bieber's private parts. I agree that what the law says is that you have to redact that and release the rest. I spoke briefly with the state attorney's office yesterday. They seem capable of putting in place technological measures to get that done, whether it's by blurring or a black line or whatever needs to be done, if that is even necessary. Again, I haven't seen the video. Last point, Your Honor, briefly on the in-camera inspection issue. We argue on behalf of media organizations blindly in every access case that we deal with because we don't have the benefit of having seen the materials, nor do we want the benefit of seeing the materials while Your Honor is doing an in-camera inspection. But I would request that rather than an in-camera ex parte hearing, that Your Honor review the materials in camera and then hold a public hearing on the issue of access. Because everybody in this room, I've done it hundreds of times, can argue the merits of their position without specifically, especially here where the issue is images and not audio. I mean, you can have an in-camera inspection, Your Honor, and then you can have a public hearing in which the defense says, Your Honor, at 2 minutes in, such and such is showed. Your Honor, and then the state can say, well, no, Your Honor, we disagree. That all should happen in public because if Your Honor is going to close a proceeding, it has to comply with the rigorous standards of Lewis. I don't think that's at issue here. So our request would be that the court, while we have no objection to the court conducting an in-camera inspection of the materials, that the public hearing where this court will make a determination about whether, or that the hearing where this court will make a determination about whether those records will be released to the citizens of the state should occur in open court.
Okay, thank you. Yes, sir.
Good morning, Judge. I didn't announce myself earlier. My name is Alexander Boxner, City Attorney's Office, City of Miami Beach. I'm also the police legal advisor. I wasn't going to speak, but I'm here in case the court has any questions. There is some clarification. We are also the custodian of records. A copy has been furnished to the State Attorney's Office. I also question whether or not the court ultimately can prohibit the release. There has been a request made by the different news agencies to the City of Miami Beach. We are obligated under Florida law to independently evaluate that public records request and identify whether or not there is a specific statutory exemption that applies. So while I understand where the court might be going with this in terms of an in-camera inspection, I also have some concerns because we have a legal obligation in order to comply with Florida law and the Constitution. And any decision that we may make, the City of Miami Beach, arguably can be challenged by the different news agencies before a circuit court judge. So I want to make sure that we're not going down a path ultimately that may result in more problems from these news medias who may say, you know what, the city of Miami Beach has not provided us that information. We will now take them to circuit court. That has happened before. That can happen here. If the court has any other questions, I'll be more than happy to
Well,
address
just to
them.
address that, I think that occurred in the Carollo case where it went to the circuit court and they basically said, no, it really should have stayed with the county court because the county court is the one that's going to be hearing the merits of the case and is in a better position to make a determination. If Miami Beach is unsure as to what your position is, I am at this time ordering the Miami Beach Police Department not to disclose the records until such time as this court has made a decision. Certainly, I'm not going to delay any this proceedings. I'm going to get to this forthwith so that everybody has an answer as soon as possible. So, just so you're at ease as to that.
I appreciate that. And will the court enter an order to that effect?
I'm sorry, say it again?
Will the court enter an order prohibiting the city of Miami Beach Police
Absolutely,
Department from
absolutely.
releasing that? I would greatly appreciate
Okay,
that.
we'll do.
Because we will, and just for the court's clarification, we will, and I'm putting it on the record at this point in time, we will ultimately deny access to those records and also assert specifically that denial is based on the county court's order.
Okay, that is fine. Now, again, it's not an indefinite order. It's certainly
No, I
going to have
understand that,
certain
but as
parameters to it.
counsel has pointed out for the different news media, there is just now going to be this delay. They're saying the delay is ultimately going to result in an actionable claim under 119. That's what I'm looking to avoid. The city of Miami Beach will rely on whatever it is the court wants to do. We do not want to get in the middle between counsel for the defendant, the state attorney's office, and a news agency. We are the custodian of records. We want to make sure that all sides ultimately are handle this matter in a way that justice so serves.
Well, let me ask you, since you are here, I mean, with respect to getting to the meat of the matter, do you people within your department, are they familiar with what's on these tapes? Do they actually have it logged where Mr. Bieber is depicted in these images so that we can just, you know, instead of having to go through hours and hours of the tape?
I believe the state attorney's office has ascertained specifically where it's at.
Your Honor, we know exactly where the tapes are. I mean, we know exactly what the numbers
Where
are.
Mr. Bieber's image is depicted?
Yes.
Okay, all right, because that's what we need to do. So we, what I would suggest, in fact, there's no objection from the defense or the media, I will ask the state to provide me with the times that he is depicted in the images so that I can see what it is that we're talking about.
Judge, if I may.
Yeah.
It's not marked by time. It's actually just a serial number. It starts off
What
with
do you
the
mean
year.
serial number?
It's basically it's a 07355 number. So it doesn't actually have a timestamp on it.
I don't think it's continuous footage, Your Honor.
Right,
I think
right.
it's a bunch of small vignettes.
Oh, the file number? Okay, all right. Okay.
Which again, I think that's to Ms. Schulman's point of, to the extent that we can identify the vignettes, if we know the vignettes that don't have this in there.
All right, if you could just identify what the vignette numbers are so that I can take a look at them.
Would you like me to do that now?
Now or shortly thereafter, we can continue with the rest of this hearing.
But the court's order is unchanged. Nothing was to be released on the
Correct.
videos.
Correct, at this juncture. Now, I would like to review these documents. It's going to take me a couple of days to go through this. If in fact there is any supplemental responses that either side, the state or counsel for the media wishes to supply, please do that as soon as you can. And I will look at these in camera. I will make a determination what my next step is going to be. What is today? Wednesday the 20th?
Today, I believe it's Thursday.
Thursday.
Shut
Thursday,
it off on Monday,
the 20th.
close everything up.
Yes, Thursday the 20th. How are we on the 27th? Okay. Availability for the 27th? You want to check on that?
Yes, sir, we're available.
You're available? Okay. David's available?
Turn it on.
Yes, Judge.
Okay.
Your Honor, while we're looking at calendars, and I should have brought this up at the beginning, and it's a housekeeping issue. Ms. Shulman and I find each of you for permission to intervene for the limited purpose of challenging the motion. And will Your Honor grant that
Yes.
for the record clearly?
Yes.
27th is clear.
Okay.
Your Honor, is there a chance we could do it on the 26th? Because we,
Well, let's find out. Tell her the 26th and 26th are tough days for me. I mean, this was a blessing in disguise that I had this calendar cleared.
Judge, for the record, I don't know if the court so wants, but the city of Miami Beach, myself specifically, I'm going to be out of town on the 27th.
You're welcome to be here, but I don't think it's necessary at this juncture, because as of right now, you're stayed from producing the documents.
Great. Thank you,
Okay.
Judge.
All right, thank you, sir.
Your Honor, we could, on the 27th, we could do it if it's like at 8:30 or 9 o'clock, first thing in the
I'm an
morning.
early riser.
So am I, so
We have time at that time, unless we do it at 8 in the morning.
8 actually might work better for me.
that's perfect. Let's do it 8 on the 27th.
I'm sorry, I'm not actually, I have another UMC hearing in Broward that morning, so that makes it kind of hard to be in two places at once.
Okay.
Till Friday night.
What about afternoon? Any time in the afternoon? I can.
No, I can't, because I have to go to the 11th Circuit in Atlanta.
Okay, on
around
that day.
noon.
All right, well, 28th is the Bench and Bar Conference, can't do that.
Your Honor, I'll see if I can get somebody to handle either this or my Broward hearing.
Okay.
I don't want
I have your
to
secretary.
hold it up.
Yeah, let me hear from the secretary. Yes. No, that's the Wednesday, yeah, forget the Wednesday, no, 27th. Tuesday the 4th, how does Tuesday the 4th look? Tuesday the 4th, I'm actually clear, I did have some conflicts on the other day.
It's fine with me, Your Honor.
Okay. Good?
We're available then.
Okay, Tuesday the 4th, and yeah, it's probably gonna be a crazy day, a Tuesday.
You know what time?
Yeah, you wanna, can you guys do it around 1 o'clock? Because I'll be in calendar till about 12. Okay, yeah, let's do 1 o'clock. All right, okay, thanks, bye. All right, 1 PM, Tuesday the 4th. Now, that's as to that issue. We also need to deal with some dates. We were on for sounding yesterday, I believe.
Yes, Your Honor, what I would suggest is why don't you delay the sounding until the 4th, and we can resolve it at that time.
We have to reset it in the system.
Yeah, all right, what I'll do is I'll just put it on the system, I'll reset it for the 4th, raise status, and then we'll get a date at that time, okay?
Very good.
All right, anything further from?
Yes, Your Honor, and
Yes.
I hate to keep beating this horse, but in light of the fact that we're not going to be here until March 4th, if there's any way that we can identify the vignettes that aren't an issue and get those out as soon as we can, I'd hate to wait another 2 weeks for that to come out, especially when it sounds like the state has got a pretty good idea. Maybe the state can guide defendant to what the vignettes are. I hate to hold that out 2 weeks.
Well, again, I don't have a problem with that. I'll hear from the defense, but I'm anticipating an argument that they may say, well, wait a minute, there might be something here that we do find objectionable, and they want to be heard on that. I don't know. I mean, are there certain vignettes that you've seen that will you be able to review it by within the next few days and say, okay, these are fine?
Well, we can certainly try to review and see if we can make some type of an agreement. We have not watched all 10 hours. I promise you, we only got it last night at about 5 o'clock.
Okay.
So we will watch it and advise the court. This is only a very small portions of these tapes. The rest of them are very boring. But if we can identify them ahead of time, we will try to do that.
Can we maybe set a schedule that by the 26th, which is 6 days from today, that
I think that's reasonable.
the defendants
6 days?
say which ones they're not challenging so they can be released?
Well, I didn't know that the news gets to run Your Honor's
No,
calendar.
but you know what, look, I'm trying to accommodate all parties. If everybody's already told me that you have no objection to the release, let's just look at them and make a
All
determination.
right, we will do our best to try 26.
Okay, 26 sounds like a reasonable plan, okay? 26. Just let the court know, if you guys come up with an agreement, you can talk amongst yourselves, and then I can go ahead and issue an order allowing the release. So the Miami Beach Police Department will also be aware of what that order is.
Right, and in terms of that order, Your Honor, it is my understanding that it's going to be facilitated through the State Attorney's Office, and the City of Miami Beach will rely on the court's order, because City of Miami Beach does not want to release anything that ultimately we're going to follow, of whatever agreement is ultimately.
Understood, but once the order is entered, you are then going to be subject to that release as well.
And I understand that.
Yeah.
It's just I'm talking about what they may initially come to an agreement that's
Okay.
releasable. We may not necessarily be a party to that conversation.
Okay.
So what I'm trying to avoid is releasing something that the City of Miami Beach is, and that ultimately was not agreed to by the State Attorney's Office, the news media.
Yeah, in other words, you will not release anything until such time as you've conferred with them and there's been an agreement as to what is going to be released.
Great.
Okay.
Thank you, Judge.
Okay, anything further from either party?
No, sir.
Okay, thank you very much for your time.
Thank you, Your Honor.
We'll be in recess. Thank you.